Good afternoon, everyone. My name is Mike Hammond. I'm the partner in charge here at O'Connor and Drew. On the panel with us today, we also have Kate Upton. She's our regulatory compliance specialist in our IT audit and security group. I've been with the firm now 10 years, starting the IT audit and security practice. We now have 35 people here in the US dedicated just to IT audit and security. So you've probably seen some of the work that we've done where we've come in and looked through your dealerships for IT security issues. Kate on the team has been with us coming up on 3 years now. Her primary focus is looking at policies and regulatory, whether it's federal or state guidance. And so she'll join us a little bit in the middle of the presentation to talk about what this new FTC Safeguards Rule entails. What parts of it exist that are relevant, and how it came to be. So as far as what this rule is, right? So this new FTC Safeguards Rule isn't really new. We're looking at enhancements to the existing rule, which is still just part of the GLBA, the Gramm-Leach-Bliley Act. So going all the way back to 1999, this law came to be to really protect consumers' financial information and wherever that financial information exists. As part of the Gramm-Leach-Bliley Act, the FTC is charged with setting some guidelines and rules as well as enforcement to make sure that businesses that hold personal information, accounting information, financial information for customers maintain secure. And so the FTC is charged with making sure that you're protecting that information wherever it exists. Early on, they had some safeguards that were supposed to be put in place by financial institutions, most primarily in the banking and financial sides, that said, if wherever this data exists, you have to make sure it's secure. What's happened now, though, is because of so many data breaches, because of what the FTC sees around companies not protecting data, they're expanding the guidance and the rules around the FTC Safeguards rules. And some of the key items that are happening in this new rule, the enhancements to the new rule, is they're including companies, and they specifically call out motor vehicle dealers. And so that's why we're here today, is to talk about how this is going to impact your organization going forward, and what we've seen already and what's about to come. So in 2019, the FTC put out some requests for comments on these enhanced safeguard rules. And of course, the industry groups, including NIST, commented on this. And so we've got some of these examples here where NIST talked about the 16,000 dealerships in all 50 states and the significant impact that this new rule would have on the environment. Because remember, the old rule said things like thou shall be secure and thou shall protect customers' data. The changes to the new rule that we'll get into are really prescriptive of what you're supposed to do, down to the ways you're supposed to do encryption and who you're supposed to hire and how it's supposed to be protected. And that didn't exist before. And so while you had leeway to protect the data in the past, they're getting very prescriptive on the ways that you're going to do it now. And so NIST had some significant comments in this period about what was needed in order to make sure that this is going to be viable for dealerships, that we weren't going to see dealers just say, you know what, the cost to comply for this is just too much, and we're going to sell, we're going to fold. And so we helped provide some metrics through both MSADA, we talked to CONNECTICUT as well, and it made its way up to NIST. They had done some work in themselves to figure out, what would it cost right now, and this was back in 2019, what would it look like if we had to, a small dealership, a mid-sized dealership, or a larger dealership group, what was it going to cost to actually comply with the new rules the way that it is written? And so we estimated it would be anywhere from $200,000 to $300,000 per year to be able to comply with these new rules. And a lot of this was because of the human cost that it was going to take to hire the people to maintain this new environment that you're going to have to protect. At the same time, the tools that you're going to have to buy in order to, the tools and the technology that you're going to have to buy and put in place to be able to comply for all of these requirements from the FTC. And there was a good number of requirements that came down the road. There's like 14, 15 different requirements that dealerships were going to have to put in place in order to comply with this. Even as recent as September of 2020, there was a conversation between the FTC and NIST around what it would take to comply, and a lot of the challenges that dealerships are going to have, particularly around the DMS. So a lot of the personal information that you're storing is stored in the DMS. And so that's not your system. It's either in the cloud, or maybe you still have some of the on-prem equipment, but it's not something that you have the direct ability to protect that data. And so it seemed kind of burdensome on the FTC to put these requirements on you and punish you if something happened at the DMS. And unfortunately, what the FTC came back and said was, that doesn't matter. It's your customer. If you're choosing to use that DMS, then you need to make sure that the DMS is compliant with all the same security requirements that are put upon you to make sure that that same environment keeps the data secure. At the same time, they said, often these DMS providers, they're national, big firms. You might not have the leverage to put into the contracts with them that you have the right to audit them, or you have the ability to go in and get your data out, or see the types of security protections that they're putting in place to do this. And all of that really was unfair. And so NIST, had a conversation with the FTC to be able to express that concern. Unfortunately, all of that mostly fell on deaf ears because so now we'll have Kate join, and she's going to go through and show you what was in the rules, in the proposed rule, and what actually made it into the rule today, and how a lot of what we presented to the FTC through NIST and through some of these trade industries really didn't matter.
Thanks, Mike. So starting at the very top of this, the purpose of the rule. The purpose of the rule is to strengthen the data security controls that financial institutions have in place to protect consumer data. So I'm sure many of you have all seen in the news hacks like SolarWinds and Colonial Pipeline. And so what the FTC is doing is seeking to lessen the odds that an individual's data is compromised by requiring these financial institutions to strengthen their security postures. So like Mike said, or what he talked about, the FTC updated and finalized the rule to require non-banking financial institutions like auto dealers and mortgage brokers to develop, implement, and maintain a comprehensive data security program to safeguard that consumer data. So the next part of this is when does the rule come into effect? So the rule has to make its way through the federal rulemaking process to become applicable. So the process involves a federal agency like the FTC and the Federal Register through the National Archives, or NARA, some of you might know it. So when the rule is published on the Federal Register, that will start the clock for when organizations should be compliant with the rule. So from the time a federal agency sends a rule to be published in the Federal Register, it typically takes NARA a few days to a few weeks. I reached out via email to the FTC individually to ask them when the rule would be published, and they gave me the highly specific answer of soon. So in government speak, I do think that means a couple weeks, probably not a couple months. So how the rule is applied. The rule applies to non-banking financial institutions, and that definition in this final rule has been expanded to include finders. So financial institutions in this sense refers to mortgage lenders, auto dealers, and payday lenders. The reason auto dealers are included is because they often offer financing themselves, or at least connect consumers with financing options. Finders refer to organizations that connect consumers with financial institutions, so like a mortgage broker or a tax preparer. So continuing this theme, so the rule applies to all financial institutions, period. So there's no threshold that would completely exempt a financial institution from being on the hook for this standard. However, for organizations that hold data for fewer than 5,000 customers or consumers, some requirements won't apply, and I'll go over what specifically those requirements are here in a second. So I reached out to FTC about this exemption directly because we wanted to know if the rule was data for 5,000 consumers annually or over a lifetime. So they responded that it was 5,000 consumers, period. So not annually, but total collectively. So what does consumer mean, right? So consumer in the context of this rule refers to individuals that act for personal, family, or household purposes. So this means that it does not include businesses nor the employees that work for them that you might service. So it's just, John Doe off the street who comes in to purchase a car to go to work or for his family. It's not someone that comes off the street to buy a truck for a landscaping business or an organization looking to buy a fleet or something like that. So exceptions. So I talked about a little bit about exceptions before. And so like we talked about, organizations that hold data for fewer than 5,000 consumers are not on the hook for every requirement in the rule. So if you're below that 5,000 threshold, you're excused from the requirements on the slide here. So again, that's 5,000 consumers. It's not, gigs of data. It's not an amount rather than actual individuals. So the requirements that you're not on the hook for if you fall under this group would be to perform a risk assessment, to implement continuous monitoring, or to do the annual penetration test if you can't do the monitoring, developing an incident response plan, and then the requirement for a written status report to management by the qualified individual. And we'll talk about what the qualified individual means a little bit later. So if you fall under this exemption, you're off the hook for those requirements on the screen right there. So what changed? So like Mike talked about, not that much. So the FTC solicited comments and seemed to disregard most of them. They sort of said, too bad, that these are the things that need to happen to protect consumers, no matter the cost. So one of the biggest changes, though, that did come out of this was before there was a requirement for a CISO, so a Chief Information Security Officer, which in my opinion is mostly realistic for small shops. Small shops are unlikely to hire someone dedicated for that CISO role. So the FTC agreed with NIST and with folks like me that think that that was a little too much. And they changed that verbiage to be qualified individual, which means that you have someone at your organization that has some level of information security training and knowledge, someone that you can prove that they know what they're doing. So whether they have a degree or maybe they've gotten a couple certifications or taken a class, has to be some kind of tangible way that you can prove that they know what they're doing. So this does not need to be a dedicated resource. So let's say you have a parts manager or you have somebody else at your organization that A, has the time, and B, also has that proper background that I just talked about in information security. It would be totally fine to have that person fulfill this role. Certainly larger organizations may want to find someone dedicated for the role, but for small and medium-sized businesses, it's totally fine to have a switch hitter in that sense. It's also acceptable to outsource the function. So you could hire a managed service provider or a third party that offers virtual CISO or some kind of service like that. You can certainly outsource it if there's no option or if it just doesn't work for your organization to have someone in-house. And I will hand that part over to Mike.
Thanks. So like Kate said, this new rule, not much changed from the proposed language 3 years ago to what actually got put into the current rule now and soon to be published. But what we want to do now in the second part of this is really to go through what are these almost 20 new rules or enhancements to the rule that you're going to have to comply with. But at the same time, what we wanted to be able to do is not make this so totally scary that there's, you feel that you've got to rip and replace everything that you're already doing. You may find that many of the controls that you have at your dealership, you're already doing. It's just maybe not in a consolidated fashion or a consolidated report that you can then give to management at the end of the year like it asked for. So hopefully in some of these next slides, we'll talk about the different things that you might already be doing, and hopefully maybe jog some of your memory and get you thinking on the things that are already in place. So, are you already compliant with having a written information security plan? In Connecticut, there are rules around having a written information security program. And so hopefully you take that document out at least once a year, make updates to it, review it, and change it based on any change, or update it based on any changes in your environment. But so this is something that you might already have in place. Hopefully you do. But under the new FTC safeguards, this will be a key document that is going to have many different sections in it. But this is definitely one of the most important documents. This is the first document that any enforcement agency like the FTC is going to come in and ask for, because this is the one that's going to guide all the rest of your information security program. The next big one that we don't see right now existing when we go out and do assessments at dealers right now is the designating the qualified individual. And really the reason for this is, while your information security plan might name someone who's responsible for security, it might, the word here really is the qualified part. So whereas before you might say, okay, the CFO or the parts manager is responsible for information security. Now it's, you have this added qualification in here about, what makes this person qualified to have this position. And so like Kate said, it doesn't have to be a dedicated role, but it does need to be commensurate with the size and the risk of your organization. So if you've got one rooftop, maybe it's a part-time job. If you're a big dealer group, you are going to start to look at, maybe this needs to be a dedicated person. Or again, it can be outsourced, but, it's going to have to be someone's responsibility to be named as this qualified individual, because there are specific tasks that this person is responsible for throughout the year and at the end of the year. Performing a risk assessment. We don't see this often when we go in to do assessments at dealerships. And it's more than just performing the risk assessment. It's really understanding, what business are you in? Where is the data stored? Who has access to that data? What protections are in place for it? What controls do you have to make sure that that data stays under your control? And what happens when it doesn't? And so we don't often see really well documented risk assessments, but a risk assessment is going to be key going forward to make sure that you know where everything is stored, the protections you have in place, and what to do if those protections fail. A key element of both the risk assessment and the information security plan is really understanding where is the data. What data do you have and where is it stored? And this really gets into creating and maintaining an inventory. And so, do you know where all of the client records are? Do you know where you're storing their personal information? Do you know where you're keeping in the dealer sheets? It's not just digital, they're looking for the paper records as well. And so where are you storing all that? And the answer can't be, or it shouldn't be just, it's all stored in the DMS. Because when we go in and do assessments, we absolutely know that we find it in more locations than just the DMS. We know that finance groups download an Excel spreadsheet onto their machine so that they can work on it offline. And the minute that Excel spreadsheet gets downloaded to someone's laptop or to a desktop, you've just extended that boundary of where all this data is stored. And so it's important to know where that data is, so that, because that's going to drive all the rest of your information security program. In that same vein, once you know where all the data is and you know the controls that are in place for it, you need to periodically review and assess it. And so whether that's an internal person, independently doing an assessment of those controls, or you hire an external firm to do it, you have to, as part of the new rule, perform that work. And it's going to be the responsibility of the qualified individual to make sure that that gets done and consolidate all of those results and give it to management when it's needed at the end of the year. Some of the more technical controls that are going to be needed going forward are things like encryption at rest and in transit. And so encryption in transit, people have done for a while. Your iPhone is encrypted, your laptops are encrypted. When you access your DMS, it's through a secure VPN or it's through a secure website with the lock on the web browser. So everyone's really used to encryption in transit. What's new and very prescriptive in the new rule is this concept of encryption at rest. Many of the dealerships that we go into now do not have encryption at rest. This is making sure that the data that's supposed to stay within your four walls, and again, not on a laptop that's going to go out the door because hopefully those are encrypted already, but the data that's staying in your four walls. So maybe you have an external USB hard drive that you leave at your desk, or network attached storage that's in one of the closets. So that data that's staying on those devices within your dealership, staying in your dealership, they're now looking to say you need to encrypt that data while it's sitting there at rest. There is a caveat to this. You can look at alternative means to protect this data. It is subject to review and approval by that qualified individual. So we're coming back to, you're going to have someone who has qualifications to be able to evaluate, okay, we can't do encryption at rest for whatever reason, but we've got these other compensating controls. That qualified individual is going to have to be able to make the decision and sign off that that alternative means was sufficient or is sufficient. Because if you do have a data breach, one of the things that they're going to look at is what were those alternative means and were they sufficient? And so again, the training and background of the qualified individual is going to come into play here. The next item that's in these the new FTC Safeguard enhanced rules is maintaining a software development lifecycle. We don't see that this will be really applicable to the auto dealers. We don't come across many auto dealers that are generating their own programs, coding their own applications. Most of it, you're using commercial off-the-shelf software. You're subscribing to a DMS platform or maybe a CRM platform. And so you're not developing your own code. Because of that, you might not need a true software development lifecycle. So we don't see that this will be that needed in the auto dealer space. One of the next one here is going to be very relevant to the auto dealers, and this is actively managing your managed service providers. And so this is very squarely on the auto dealers with your DMS provider. So the FTC is not going to accept that you give the data to the DMS and now it's the DMS's problem to make sure it's secure. They're going to make sure, they're going to want to know what are you doing to make sure that that DMS provider is keeping good controls around your customers' information. And so they're going to want to make sure that, maybe you've asked the DMS provider for a SOC 2 report. And it's not going to be sufficient that you got the SOC 2 report and filed it in a drawer. You're going to have to review the SOC 2 report and make sure that you understand what are the controls that the DMS provider has in place, and are they missing something that you would expect? So are you expecting that they have encryption at rest? And maybe the DMS provider doesn't have that because they didn't realize that that was a requirement for them. But even though it's not even though they're not doing it, it's still a requirement for you. It's your customer. And so, just getting the SOC 2 report is not going to be sufficient. You're going to have to go through that report and make sure that that outsourced provider is doing everything that they can to meet your requirements for that customer's data. Maybe you have a managed service provider that takes care of your laptops and your desktops and maintains your network. If they're an admin of your network and they can see that same data, your customer's data, your customer's personal information, what kind of due diligence did you do against that managed service provider to make sure that they have all the controls in place that they need to make sure that they're keeping the same level of controls over the data that they can see that you're supposed to be seeing under these enhanced safeguard rules. The actively managing the MSPs is probably one of the larger more time-consuming ones that we're thinking is going to be burdensome for the dealers. If you are over the 5,000 records, you're looking at having to establish an incident response plan. And so these are the types of documents, have you gone through the exercise of understanding when you have, or if you have a breach, what are you going to do? Who do you call first? Do you call law enforcement? Do you call your attorneys? Do you call your insurance company? Do you call your IT company? All of that needs to be documented in a plan. In the plan, they also talk about, running through it. And so it's not just good enough to have a Word document sitting in a drawer somewhere. You're going to have to develop that policy and review it to make sure that it keeps up with your environment based on any changes that are in there. Some of the other technical areas that you're going to need is implementing multi-factor authentication. So many of the dealers that we talk to are starting to move towards the two-factor authentication, where it's something you have and something you know, right? So you log on to Office 365 in the cloud, you enter in your user ID, your password, and then you get the notification on your phone to enter in the 6 digits. The FTC this was a very clear new enhancement to the rule about having multi-factor authentication everywhere, every system that you have personal information of your customers, the financial information of your customers, you need to make sure that you have multi-factor authentication. So does your DMS provider have force you to use multi-factor authentication, or at least give you the option to turn it on? If you VPN into your network, are you using multi-factor authentication? If you've got Office 365 in the cloud or the Google Docs in the cloud, do you have two-factor authentication turned on? So this is something where you are going to have to look at some type of technical solution if the vendor that you're working with doesn't provide it. Remember, I talked about the need to know what data you have and where it's stored. One of the key requirements is going to be around the data retention policy. Right? So do you know what data you have, where it's stored, and how long you're storing it for? And when it's no longer useful, do you have a policy in place to destroy that data? And again, this is going to come back to, if you haven't done an inventory of where all that data is sitting, you're not going to be able to know where to go when it's time to actually destroy the data that's no longer needed. Another area that we don't see that the dealers are going to have, or we don't believe that the dealers are going to have a big play in here, is around the change management process. Again, we don't see that you're going to be deploying a lot of your custom applications or making large changes or making multiple changes to applications, other than maybe what you get from your DMS provider, or if say you move to a whole new suite of tools, maybe then you'd have to talk about change management and who approved it, who approved moving to the new environment. Was their tests done ahead of time? Did your users, did you give them some kind of use case tests to make sure that everything worked as they expected, and the security, most importantly, is still there? On large projects like that, we'd see this happen, but we don't see that this is going to be an overly burdensome process for the dealers. There's not a lot of changes. Again, you're not a software development shop where you've got to review these things before they get rolled out into production. So we don't see that this will be a big overhead for you. One that we do see that will be a big overhead, and will both in the personnel costs and in technology costs, is the monitoring and logging of activity. So as part of the new requirement, you may right now be logging what happens when someone forgets their password or a failed login attempt, if someone's trying to break into your firewall from the outside. So you might see those failed logins because they don't happen as often. What the new requirements are going to have is the requirement to review successful attempts, successful logins. And so you'll now need to record who logged into a server, who logged into the DMS, who logged into that desktop, wherever your customer's data is stored, who had access to it, when did they access it, and what did they do with it when they accessed it. And so having to record successful log activity adds a significant amount of time and overhead to your environment. And so we see that this one in itself will be a big amount of effort, both personnel-wise and technology, because it's not just going to be having to collect the logs. Someone's going to have to monitor and do something with those logs. They're going to have to know how to respond to an alert, know what to do when there is suspicious activity that's happening. So the next item, and again, this next item here is going to apply only for consumer dealerships with over 5,000 consumers, is around the continuous monitoring and pen testing. And so for those dealerships that have us come in and we do an assessment once a year, under the new rules, that's not going to be enough. They're going to look for continuous monitoring. They're going to want to know that on a weekly basis, you're scanning all of your machines for vulnerabilities. You're scanning for missing patches. You might annually or biannually do an external and internal pen test to make sure that any of those vulnerabilities that do exist, they can't be actively exploited. And so this one alone will be a significant cost, nowhere near as much as probably the monitoring and the logging activity. But for those dealerships that are over 5,000 consumers, the continuous monitoring is going to be a significant amount of work. Last slide here on, are you compliant already? And so the qualified individual is going to be responsible for maintaining these policies and procedures. So of all the things that we talked about before, the continuous monitoring and the logging and the encryption and where the data is stored and the information security program, all of that's going to have to be maintained. All those procedures are going to have to be documented and approved and maintained by that qualified individual. And so there'll be a strong component that, they're going to want to make sure that you've documented everything that you say that you're going to be doing, because they're going to use those documents to evaluate their design and then potentially the effectiveness to make sure that it's working. Obviously, if they're coming into your shop to look at something, something probably happened. You might have had some breach at some point. And so they'll use that information, the breach itself, to say, obviously the controls weren't working as designed because you had the breach. Another component is the establishing the security and awareness training. The employee, the human element, is still considered the weakest link from getting attacked from the outside. And so if an employee can click on a link, and unfortunately that allows a malicious actor to come in from the outside, because of that, they still want to make sure that you have a robust security and awareness program. So things like when a new employee joins the dealership, do you have them review your information security program so they understand what they're supposed to be keeping secure? Do you do annual reviews, reminders on your information security program for all your employees so that they can be reminded what's happening? And do you do continuous email campaigns throughout the year to continuously train the employees on what are new types of attacks that are happening, and so that they can see what makes for a legitimate email versus a phishing email, and kind of help them understand and look out for those red flags on when not to click. And then importantly, what happens if they do accidentally click? Who are they supposed to call? What should they do with the email? What should they do with their computer? And so there is a component of employee awareness and training in this new rule, or the enhanced rule. And then lastly, this qualified individual who's responsible for all of these things that we just spoke to, at least annually, is supposed to report to internal management on the status of the compliance of the program. And so they have to go through and say, we've trained this many people, we've done this type of awareness and security. We didn't have any events related to an external breach. We had this many failed logins. This person's going to be responsible for making sure that the risk program is done and providing all of this to maybe the owner of the dealership or a board if you have one. So there is a lot to this new FTC safeguards. All of it, the FTC will say, has always existed. What they're doing now in these enhanced rules is being really more prescriptive, which unfortunately is going to come down to bite us later when we get into enforcement actions. This dealer built, we went through the FTC website to try to find one data security breaches where the FTC came in and there was some type of data security issue, or 2 that were specifically related to the dealers. And so for the data security, there were about 53 enforcement cases recently. But on the dealers, there's not a lot of enforcement action against dealers related to data security. Where we see enforcement actions on dealers is really around deceptive practices, primarily on things like how they tried to sell cars, move dollars on the deal sheets, things like that. But when it came to the dealers themselves related to data security, we didn't find many of those. So the best case we could probably find is this DMS provider called DealerBuilt. And so a few years ago, the FTC DealerBuilt had a data breach, and the FTC came in to look at what happened. And so many of the things that you see in the enforcement actions for DealerBuilt, and this was done a couple of years ago, most of the things that we see in the DealerBuilt example are word for word, literally what is in the new enhanced rules. So things like DealerBuilt actually stored customer information in clear text. And so because of that, we now see the reasons for storing data encrypted at rest. They didn't have a written information security policy. They didn't provide reasonable data security training for the employees, which is why we now see the enhanced requirements for training. They didn't assess the risks for the network, which is why we see that you have to perform a risk assessment. They didn't use their security measures to monitor unauthorized attempts. And so at the same time, now we have the requirement to look for authorized attempts. They didn't have accessible controls in place, and they didn't select and install secure devices. So everything that really happened from DealerBuilt is now really what we're seeing, almost identical to what ended up being put into the enhanced rule. So then now what's the requirement for DealerBuilt? What's happened after the fact? So as part of an agreement with them, instead of potentially a monetary fine, DealerBuilt now needs to provide, in addition to, excuse me, in addition to doing everything that the Safeguards rules required of them already, they also have to report the compliance of their program to the FTC each year. And so the overhead and the management overhead of making sure that those documents are correct and everyone's in agreement before you hand over what your environment looks like to a federal agency, obviously there's a dollar cost associated with that. So, while they might not have had a monetary fine, they definitely had to put in a lot of policies and procedures and people cost to make sure that they're doing this. And then under this new rule, they also have to do this for 20 years. And so for the next 20 years, they have to keep at least 5 years worth of data every year for all of the procedures or most of the procedures that they're doing. And so when it says certain records for 20 years, we went through the certain records, and it is all the customer information, all the results of testing, the independent, one of the other things that the DealerBuilt has to do is they can no longer be trusted to do an internal audit themselves. They have to have an external auditor perform the work. And so now this external auditor has to go in and provide the results of the testing to management. Management then needs to give it to the FTC as well. And so, that's the type of enforcement actions that we're seeing right now from the FTC, is that when something happens to your environment, they at this point don't trust that you can handle it yourselves. They'll require an external auditor to come in every year and test you on that program before they get to that next level where it might be monetary fines, something like that. So we've got the next few slides are for, if you've got dealerships in Massachusetts or overlap into Massachusetts. Massachusetts has a pretty comprehensive law around MA 201 to make sure that you have a written information security program. If you're complying with this law already completely, you're doing much of what's needed in the new enhanced FTC Safeguards rules. So if you're doing, if you already have a WISP, if you're already reviewing your third-party service providers, you're already annually reviewing the program, much of this is already going to be happening. What we want to talk about, though, is for Connecticut. So Connecticut, we did, Kate typed up some documentation I know Ann sent out to many of you that talks about a new Connecticut law that went into place this year, basically an act to incentivize the adoption of cybersecurity standards for doing the business in Connecticut. So what Connecticut's now doing is saying, if you are putting in a program, an information security program, and you've done it, it's the best you can, right? None of us are going to be able to compete against nation states overseas, but if we've put in all of the protections that we know that we can do in a reasonable manner, the new law prevents the court from assessing these punitive damages against you if you created, maintained, and complied with your program. And so now what Connecticut's hoping to do is say, like, look, we're going to incentivize you to get this done. If you get it done, you might be off the hook for any of these punitive damages. What's happening is companies like the insurance brokers are saying that, we're tired of paying out these claims. And so if you don't have two-factor authentication turned on for your Office 365 or your Google Drive online, we're not going to renew your insurance policies. And so we're now seeing these types of programs coming out of the insurance and the regulatory space where they say, like, look, we're going to help you be compliant with these data. We're going to help you protect this data. And, that's not enough that you were doing it on your own before or proving, we were assuming that you're doing it on your own. We're now going to incentivize it, whether we either the carrot or the stick, right? It's either going to be, we're not going to give you the insurance if you don't comply with it, or we'll give you like get out of jail free card if you do prove that you did have a good program in place. And so in Connecticut, if you are complying with some of these National Institute of Standards and Technologies publications like NIST 800-171 or the Center for Net Security, Critical Security Controls, or something even harder like ISO 27001, if you're compliant with those security programs, you might be able to get off the hook on some of the punitive damages. And so all of these programs that you see here on this slide, any one of these are going to help you be compliant with the new FTC Safeguards rules as well. So we gave you a lot overview of what's happening. As Kate said, this is coming pretty soon. It's going to be in days, maybe a week or two. It's not going to be months. When it does come into play, when it does get put into the register, you'll have 30 days to be compliant with some of the rules and 12 months to be compliant with all of it. Again, it'll be, it's not going to be one of those where the FTC is going to come in and, or I don't assume the FTC is going to come in and check on every auto dealer. It's really going to happen when, if and when there is a data breach, how hard they're going to come down on you for not being compliant. If you have a perfect program in place, you're doing everything that you said you would, and it's documented well, there's probably going to be less of an enforcement action against it. It's really going to be on the ones that are just willfully negligent. Accidents happen. The nation state actors overseas are well more equipped than we are at defending. And so they're going to get in if they really want to try to get in. But if you do have a data breach and you don't have any of these controls in place, or not all of these controls in place, this is where the FTC is going to be able to go after you for it. So hopefully, today's session give you some ideas and food for thought on what you might have to do at your dealership. If there's any questions, definitely feel free to reach out either to me or Kate. We can get back to you on quickly on some of these. And again, this session's recorded. And so once it's rendered through Zoom, we'll make it available to Ann and be able to get it out to you. So thank you for spending an hour with us, and everyone else, have a good day.